The vast majority of clinical negligence claims funded by Stephenson's are funded by no win, no fees. And we are often asked questions largely related to what happens if we lose. So let's start there. What if you lose and your claim is funded by a no win, no fee? I'd like to start by saying if we've offered you funding, we are reasonably confident that your claim will be successful. However, without medical records and without independent expert reports, it's not always possible to accurately determine the final outcome of a claim. And there will be some claims that lose and will be unsuccessful. If we're unsuccessful, then the general principle of a conditional fee agreement, a no win, no fee, is that you will not be charged by Stephenson's provided you act reasonably. Reasonably is defined within the agreement, but it largely relates to not lying and providing instructions in a timely fashion. Although we will not look to charge you for our fees, there will be disbursements which are incurred throughout the investigations of a claim. These might include obtaining expert reports or court fees. It may be that we recommend taking out an insurance policy to protect against these costs. And an insurance policy works in exactly the same way as a no win, no fee. There is no upfront cost to a premium. It only becomes payable if we are either successful or if we're unsuccessful and a client has acted in an unreasonable way. If we are successful with your claim, then the lion's share of the insurance premium will be paid by a defendant. However, there will be a shortfall, and that will come directly from your compensation. At no time will you be asked to provide money up front to cover the cost of the insurance premium. The extent of the cost of the insurance premium will also depend on the final value of your claim. In addition to a deduction for your insurance premium, there will also be a deduction from your compensation for what is referred to as a success fee. Stephenson's are taking a calculated gamble by offering you a no win, no fee, because essentially we will not be paid unless we are successful. To reflect that risk, we are entitled to deduct up to 25% of your claim relating to pain and suffering and past losses. There are a few really important points to make about the 25%. It is likely that if you do a search, you will find firms that are offering what might appear on the face of it to be offering more favourable terms. They might be offering to take less than 25%. It is important that you consider whether those firms have the same expertise and experience, not just to win a claim, but to make sure that you receive the compensation that you're entitled to receive. In addition, although we are entitled to take up to 25%, it is very possible that we will take less. And there are two main situations where we will take less than 25%. The first situation is that we are unable to deduct more than our final costs. So given a numerical example, if a claim settles for £100,000, in principle we would be able to take 25%, which would be £25,000. However, if at the time of settlement costs are only £10,000, as we cannot take more than our final costs, the deduction would be £10,000 rather than £25,000. The second example is that we cannot deduct for a success fee from any future losses. These are losses which have not yet happened. Future loss of earnings, future care claims, future adaptations to homes. Given the same numerical example as before, let's say the claim settles for £100,000. However, in this situation, £60,000 relates to future losses. That £60,000 is ring-fenced, would be a client's in full. We would then take 25% off the remaining balance, the £40,000, meaning that the success fee would be £10,000, subject to final costs being more than £10,000. So in summary, if you've been offered a no win, no fee, we expect you to win. If we don't win, providing you act reasonably, you will not be charged. If we do win, you will receive compensation. From that compensation, there will be deductions. There will be a deduction for your insurance premium, and there will be a deduction for a success fee, which could be up to 25%. It's very difficult at the outset of a claim to be able to advise on what final costs are likely to be, because this will be dependent on the defendant's attitude. If the defendant makes earlier admissions, then less work will need to be done, and legal costs will be less. It's also very difficult to predict future losses without the input of independent experts. However, we can give you the certainty that you will not be asked to make an offer or consider an offer unless you know exactly what you're going to receive in your hand. For further information about no win, no fees, please do not hesitate to contact a member of our specialist team. Thank you.